If Richard Allen's defense team thought that things would get easier when they started on their case instead of just defending against the prosecution, they were badly mistaken. Today was a very tough day for the defense. Roadblock after roadblock. The witnesses who didn't want to be there couldn't remember anything, even what they said 3 or 4 weeks ago. The prosecution objecting to lots and lots of questions. And I don't call out lawyers, but tonight I'm calling out and a judge who is ruling against the defense over and over again and may just have taken away their very most important witness, as it turns out. Did the defense make any headway? What's happening in the case? Has the prosecution proven its case? And what is the jury thinking? We are going to get into all of that tonight. And hi, y'all, and welcome to tonight's live stream. It has been quite the day at trial. Everyone was exhausted. Oh, my mic. Thank you, Marlon. So, okay, sorry. All right. So it has been quite the day. I mean, really, truly a wild and crazy day with ups and downs and twists and turns. We will get into all of that. I want to say a special hi and shout out to Carlin and Barb and Piper and Christy, Lisa, Megan, Jen, Jenny, and Scott. Huge shout out to Bonnie for line sitting for me twice. She drove a long way, went to a lot of trouble to do it. And thanks to Jolene. And I've got tons more people to thank, but we'll hold off till the very end. So let us dive in because there is a lot to cover about today. And that was even though we spent a tremendous amount of time in sidebar and in private conferences with the judge. We recessed over and over again all morning while they tried to work out some evidence things that were just really difficult. So let's start out. When we first started the day, everybody was commenting that the defense looked so much more relaxed. Richard Allen, I saw him smile. And some of the defense lawyers were just talking to each other, looking kind of relaxed. Well, that lasted less than 15 minutes, probably something like 10. And here's what happened. The very first witness out of the gate, a man named Christopher Goatee. And he was, OJ had him on direct examination. He is with the police department. I think she said Hanlon Police Department, but he was also assigned to the FBI GRIT Task Force, and that's Gang Response Investigation Task Force. They do kidnappings, murders, and things like that. So really significant crimes. And he was teamed with Adam Pohl, an FBI agent. The two of them conducted investigations, interviews specifically with a number of witnesses in this particular case. It was 14 to 21 days worth of interviews is what they did. And they interviewed Brad Weber, who is quickly becoming one of the most important witnesses in the entire case. All Brad Weber did, well, depending on who you ask, but all he did was drive down his own driveway. That's it. That's the only thing he did. Most important witness possibly in the entire case. Why? Because Richard Allen, in all of those confessions that we went over day before yesterday and yesterday, there was one fact in there that was unique, that was not something that could have been known to somebody else. If it's true, Richard Allen said that when he abducted the girls, he had planned to R them or SV them, and that his plan got interrupted because as he was executing it, a van drove by and he thought he was, I guess, alone kind of in the woods with the girls, but the van drove by. He got scared. At that point, he decided instead of doing what he had planned to do to the girls, to murder them. And that was what he did. He said he waited until they had died and then left the scene. That van became all important because the prosecution believes it can prove that Brad Weber drove his van down his driveway right next to where Richard Allen was with the two girls. That's what he claims. And so are they right? Are they right? It's going to be so important. The defense thinks they have killer evidence that this is fake, that Brad Weber did not simply drive down his driveway at the time he said. According to him, he clocked out of work at 2:02 and came straight home. 2:25. I think the way they estimated it for the defense was, for the prosecution, was 2:27 to 2:30. Right in that time frame would have been when he came home. We looked last night at the timeline. That is tight. But the whole timeline is really tight for Richard Allen to have committed these murders. He has to have met the girls and killed them all within something like 20 minutes. That's amazing. And they moved a good distance over the course of that time. But so for Brad Weber to have gotten there at 2:27 to 2:30 and startled Richard Allen has to have killed the girls, gotten them, I don't know where they were, but across the creek and up the other side. Maybe they were already across the other side, but he has to have gotten them all the way over there in time for them to have died within something like 5 minutes of that time. It's that'll be interesting to see how the defense handles that. I'll add that to the stage real quickly because it's every bit that important. So there you see at 2:32 is the last movement of Libby's phone. At 2:13, I put the really big things in red. At 2:13, Libby captured the video, 43 seconds. It shows what everyone believes, I think even the defense would acknowledge, is probably the abduction of Libby and Abby right at the end of the Monon High Bridge. They were told to go down the hill. For them to end up where they ended up, and let's go ahead and add this map to the stage. So their body, there's an X there where you can see where their bodies are found, but you see the Monon High Bridge over there? That's where they were abducted, at the end of that. There, and the very end of that, they were then, and I think it may have been, I put the Monon High Bridge marker that you see there is right at the front, but I think they actually were abducted and I'm just showing you where the bridge is, where it crosses the creek, but they actually were abducted further over as the bridge ends. You can't definitely see where that is now. I don't know if you can see my cursor. I think it's somewhere in there. So Brad Weber was driving along the path that you see at the bottom. You see the Weber home listed there. And I think that's correct. I think that's where the Weber home is. According to what the prosecution believes happened, you see where the bodies ended up. They're on the other side of the creek. They're on the north side of the creek, not the south side where the girls were abducted. So at some point, the girls had to have been ordered to switch clothes because Libby had nothing on. Abby had on some of Libby's clothes, and clothes of theirs were deposited in the creek at some point. They were herded across that creek and then forced back up the other side, which was a steep hill as well, where their bodies were found the next day. So Richard Allen said that a van startled him. We don't know where he was in this process, but we've been told that you can't see the other side of the creek from where the bodies are. So that's not where he was at the time that the van went by. So anyway, 2:27 to 2:30 is when Weber says he went through there. The defense thinks they have some bombshell information that could change everything. And that's that early on in the beginning of the investigation, Weber told the FBI, he told specifically Christopher Goatee, and he told FBI agent Adam Pohl that he didn't go straight home after work. Instead of going straight home, he has apparently ATM machines. He went to service them and take care of them. He was having some kind of difficulty with them, went to do that and got home later than that. That completely destroys the defense, the prosecution time frame, because as you can see, moving this back to the screen, the last movement of Libby's phone was at 2:32 p.m. So they believe that, and Libby's phone was found underneath Abby's body, underneath Abby's dead body. And they believe that Abby's body did not move, that she died exactly where she was, lying on the ground right there. So we will pull that out and head back over here. All right. So according to the testimony of Christopher Goatee, which did not go, that's the defense plan, He admitted he interviewed Brad Weber. And the question that was asked by Auger for the defense was, what did he tell you about what he did after work? Objection, hearsay. And Auger says, well, this would be a prior inconsistent statement. And the judge said, well, it's used, I'll let it be used for impeachment. One of the few things that they did win for the day, although then she told the jury this is just for impeachment. And she said, he said he went home. I don't know if, and she said, but you mean went straight home? Because clearly that is not what the report says. She said, would it help you to see the report, the FBI report, to refresh your recollection? And, you know, is that a report you wrote? No, it's not. That was a foundational question from the prosecution. But does it refresh your recollection of specific things? Now, probably the witness should have answered no, but the witness said, yes, it would refresh my recollection. So, okay, they hand it to him. And here's what happens. And I think I've got these about right in the order. And I just wrote WTH on the side, like, what? Did that report refresh your recollection? Yes, it did. So in other words, he's looked at it and now he's remembered something from what happened. The report almost surely says that he went to, the report says that he went to check ATM machines, right? And he didn't know. Did he go somewhere else first? I don't recall. And she looked at him. You just refreshed your recollection. You're holding the report in your hand that or at least you just read it. I handed it to you. You read it. It said he went to check his ATM machines, or almost surely went to check his ATM machines. And you said it refreshed your recollection, and yet you don't know it says that. And he says, but you don't recall if he went somewhere else first? No. And at that point, she just gave up. She said, okay, no more questions. There was no cross-examination because this was really good for the prosecution. And Auger headed out of the room. So here's the thing. If he looks at the report and it doesn't refresh his recollection, he doesn't remember anything based on that, then it doesn't come in. He didn't write the report. So even though it's sitting right there in front of her and she can see it, the frustration level, because he's not acknowledging it. He's not saying that he actually said that or actually heard that when he did the interview. So at that point, there were plenty of machinations going on in the background, running around, people doing stuff. So that went on all day long. But meanwhile, in the courtroom, we moved on to the next witness, Dr. Edith Wadner. Although there was great dispute over whether her name was Wadner or Winger. I'm on the gallery. I don't really know. It's hard to hear. So at this point, we had all the lawyers in the back of the room again. Every now and again, when one of the Department of Corrections employees has come up, all these people will fill in the back, and all the lawyers sitting there with their pens, and it has something to do with their concern about lawsuits, I think, or about compliance with various promises that they made. There was a settlement agreement of a suit against the Department of Corrections a few years back. And so it has to do with that, but I don't know all the details. They don't check in or sign in or tell us who they are. So this Edith Wadner works for the Indiana Department of Corrections. I think she said that Centurion, she actually works for Centurion, although the person next to me felt like she said other people did, but she worked straight up for the Department of Corrections. Either way, she oversees the contract between the Department of Corrections and Centurion. And so that meant she was over Walla, who testified a couple of days ago. And she talked about Richard Allen being sent to Westville, the correctional facility, and being transferred to Wabash. She said, one of the important things she said is Richard Allen supposedly was placed, instead of in jail, he was placed in a prison. And he was placed there, they said, for his safekeeping. He was under a safekeeping order because they were worried that he might be hurt by other inmates because of the charges against him. So they put him in this particular place, but he had a significant mental health condition, a major depressive disorder, as well as anxiety. And everyone admits he qualified to be under mental health care, but he was not sent to one of the 3 places that are designated for that within the prison system. It would have been Newcastle, Pendleton, or Wabash Valley. He eventually was transferred to Wabash, but even then, he wasn't put in the specialized unit for mental health issues. So at no point was he put into a mental health facility, as he probably should have been. And that created a lot of trouble, because that meant the rules weren't really clear on how he ought to be treated, which is how he ended up in solitary confinement for over a year, which caused his mental health to deteriorate dramatically. So in early 2023, Walla, who had testified already, Dr. Walla, testified that this witness said Walla was advocating for Richard Allen to have a visit with his wife. In the course of a year, he only got to visit with his wife twice. And the reason was because in the solitary confinement unit, which is more typically for a punishment for, say, 30 days, he was literally placed there, and no one in this unit got visits with family. That would make sense, perhaps, if it were punitive and short term, but when you're truly housed there for over a year, that's what he got. So she, and this witness, Dr. Wadner or Winger, whichever it would be, had been told by Walla that Walla was interested in true crime and following podcasts and knew some about the case involving Richard Allen. It did sound like it had been downplayed a little bit, either by Walla or misunderstood by Wadner, but nonetheless, she did have information to tell her that Dr. Walla knew about the crime Richard Allen was charged with committing. Now, no one has suggested that the facility knew that Walla was also researching or did some searches within the prison to look at the file of another prisoner who was also a suspect in the same crime Richard Allen stands charged for. So Richard, the problem that they ran into is there were 2 different categories that Richard Allen fell into. On the one hand, he was in an administrative classification called safekeeping. And that's where they keep him somewhere specific so that he's protected from the main population because he might be really at risk. On the other hand, he also met the criteria for D code, which was in her department, and that normally would entitle him to individual therapy related to his condition. And there would also be rules around that from that settlement agreement I mentioned earlier. And the rules around that would include things like you cannot be in solitary confinement for more than 30 days. Well, he was in there for over a year, and his health deteriorated because of that. And she acknowledged that would be to be expected. She said that normally when they have somebody, and they've only had, I think she said 9 safekeeping people connected to theirs, half of them go to Newcastle, which is specific to mental health, or has at least a unit that is, and then they get treatment at the state hospital. But she wasn't sure. This conflict meant there weren't kind of rules around this. And so he just fell through the cracks. I mean, that's what it sounded like to me. He didn't receive what they all admitted he needed. They could see the train coming and nobody moved him out of the way. So she talked about the in-cell video, because he was videoed in his cell at all times. And his movement when he was let out of the cell, he was shackled as well as handcuffs. He was led on a leash, and a video camera followed him around the prison, so that he was literally videoed 100% of his life, like Truman or something. And so she didn't know why that was being done, but somehow someone ordered that, whether it was for safekeeping or whatever reason. So they never stopped doing that. 100% of his life was on video there for a time. She said she had concerns about the impact of this video on his mental health and recommended that he be removed. She was concerned about his depression, but it never happened to her knowledge. He was not moved. And the longer this went on, she said, the longer he was held in this segregated position, the more damaging that would be to his mental health. She said, if to some degree, it might not be damaging in itself, but it was damaging over time, maybe a little bit of it, but this was very severe. And the longer you're in it, the worse and the worse and the worse it got. So that 30-day rule that should have applied was never applied to Richard Allen. And so he was never released from this or given any alternatives. She did say she felt like he fell within the class of people who should have been seriously mental health problems, and therefore they should be classified and given the protections and treatments of that order. She said, we discussed when his mental health declined and we weren't sure what we would do. He at one point met the criteria for grave disability, and the goal in that case would be to prevent him from mental health decline. Segregation was making it worse, and that long-term segregation could easily lead to harm. The policy reflecting serious mental illness, and in putting him in restrictive housing, he said we didn't want him to just stay there and to go to a mental health unit, but that never happened. They wanted him to be transferred, and it didn't happen. He continued to stay there and stay there. And at this point, there was a question, hasn't the Department of Corrections been in previous lawsuits about mental health inmates? Sidebar, prosecution calls it sustained. And that was because the judges already ruled out any reference to that lawsuit that had been filed earlier in the agreement by the Department of Corrections to how they were going to deal with mental health problems going forward. The judge said, you don't need that settlement agreement, which apparently was more detailed. All you need is the rules that came out of that. You have those rules. You're allowed to use those. You can't put in the settlement agreement. So then the cross-examination began, and the witness acknowledged that Allen wasn't seriously mentally ill at the time he entered, but that he was classified as having a severe mental illness, a serious mental illness, which entitled him to the protections to prevent it from becoming seriously mental ill at the time. So he had a previous diagnosis, as I'd said, but he wasn't mentally ill right then and there. And she also talked about on April 23rd, that Dr. Walla came to her and to another employee, the doctor who was the psychiatrist over the unit. And she said, look, I think he's feigning, or which is faking, basically. I think he's faking it, but I'm not really sure. I would like your opinion. Can you tell me what you think? And she asked them for a multidisciplinary team, and they sent someone to see him. And at some point, she said right about then, it became clear. In fact, she said it became clear 10 days before Wallace said she was faking, and they had this multidisciplinary team meeting, which I can't explain, but that it became clear that he met the criteria for involuntary medication. And it was, in other words, he's not going to just get better. He faked it until he made it. He actually managed to get, even if he was faking it, he's now severely mentally ill, and we have to medicate him because it's not going to stop on its own now. He can't just click the button and say, no, it's no longer a problem. So, and let me correct that. The first meeting was on April 13th of 2023 when the multidisciplinary team first met. And that was Walla, this witness, and Dr. Martin. So by grave disability, she explained they were talking about he was not caring for himself, and his symptoms were severe. They were unlikely to stop. He wasn't eating. He wasn't sleeping. And so even if he chose, whether he had initially decided, I'm not going to sleep, decided I'm not going to eat, it was now at the point where it was affecting his mental health, and they had no choice but to go ahead and medicate him, which they did with Haldol, which is used for psychosis. She talked about the conflict between safekeeping, where the goal is to keep him safe. So if he's all alone by himself, boy, he's really safe, right? Nobody can reach him. And that ended up taking precedence and could be handled right there where he was in solitary, but it took precedence over any of his mental health care. So there was a juror question at the end of this. Does the DOC ever place safekeepers in the general population? The answer was yes. And then follow-up question, the person wrote down both. What prevented that for Allen? And it wasn't a juror question. Sorry, that was a follow-up, I think, by the defense team. What prevented that for Allen? There was an objection to that by the prosecution, and it was sustained. So the witness was never allowed to say why Allen wasn't able to be put in the general population. The truth is, nobody really has an explanation for that. He was placed in this bizarre position of being in a prison when he hadn't even been convicted of a crime. Normally, you go to jail until you're convicted of a crime, at which time you're moved to prison. None of this was set up for this. So he fell through every possible crack and ended up in a horrible situation that absolutely should not have happened. And there clearly needs to be some reform around this. This is regardless of whether he is guilty or not guilty at the end of this trial. This should never have happened to him. This absolutely should not have happened. And there need to be protections in place so that it never happens again, so that no one else falls through the cracks like this man did. All right. Let me see if there's anything else I'm going to tell you on that witness. All right. Now, I think that's good enough. Oh, some more juror questions. I highlighted a bunch of them. They were all really interesting. All right. Could it be, and a lot of these had to do with the confessions that we heard yesterday. So you know for sure that he was, that they are thinking about those confessions and about what they mean. Could it be that he was faking his symptoms so he wouldn't be moved to populated areas because of the fear of being harmed? And the witness says, well, okay, could be. I don't know. I don't know what was happening there. And so the defense asked, well, if Dr. Wallace said that he didn't have an opinion or she didn't know, would you defer to her because she was actually treating him? And the witness said, oh, yes, I would definitely defer to the person who was actually treating Richard Allen. She did say she never heard anything about threats to Richard Allen by other inmates. Now, the next question, when somebody is faking, and regardless, they said, whether they're faking or not faking mental health, could a person slip in truths in a confession? And the witness said, I've seen it both ways. Psychotic people who confess to what they did, and then I've seen it the other way around where the person is not faking, is faking. And it doesn't matter. I don't know. She basically said, I don't know. Could you slip in truths? Yeah, you could, or you could be totally making it up because you are psychotic, and I can't answer that. At this point, the witness went into major testimony that I think the defense was utterly unprepared for because it came from a juror question. This was not an expert witness. This was not someone who was named for this, but she was answering the jury's question because they really wanted to know about this. And so on cross-examination, Diener, one of the prosecutors, stood up and said, well, if a statement is made during mental health symptoms, what should the jury look for to determine if there is a mental health basis for this, as opposed to if it's true? And what she explained to the jury was that the type of conversation would be different. Now, the defense probably should have objected because there was a whole lot of information. She just rattled all this off, and I think everyone was sort of overwhelmed. In fact, Diener was like, okay, so to summarize, because it was really overwhelming, she said, you look to see whether the person is detached from reality, not talking in a linear way. You look at their body language. That's not going to help us because we didn't get any body language. There was no, while there should be video of this, right? He was videoed 24 hours a day. It isn't connected up to the confessions that we have. And she said that the organization of what they're saying, if they're psychotic, is chaotic and pings off in different directions. which we clearly did see in some of the confessions that the guards wrote down. We would see he would make a confession and then talk about something just bizarre that had nothing to do with anything. More interesting probably is going to be how the jury applies what she said to the confessions to his wife and to his mother. She said, so if it's organized and it's fully directed, the whole conversation, then that would suggest that this is the truth. If it's chronological, that would suggest that it's the truth. So she said there are 5 things that would be looked for: grandiosity, hyper-religiosity, jealousy, command, which would mean somebody telling you to do things, and persecutory. But she gave really big examples of these that wouldn't fit. For example, hyper-religiosity, she said, I'm Jesus. And that would, so at no point, although clearly Richard Allen had become very hyper-religious and was, for example, eating his Bible and so forth. But even though that would be the case, he certainly never reached the stage where he said he was Jesus. So she said it also could be, he's commanded me to do such and such. For command, she said it would be like the TV is telling me to do such and such. So those were really big things. And it depends on what the jury does with them, whether or not the jury applies those and how strictly to what exactly they heard in those confessions. She said that you might look for statements like, God told me to such and such, or everybody loves me, so I such and such. Neither of which we really heard anywhere in there. We did hear Richard Allen say that he wanted to go to heaven, that he wanted to see his family. I felt like the defense was kind of unprepared for a bunch of stuff that headed their way. I think that they had no idea that was coming, and no one could, because it was an answer to a juror's question. So another question is delirium when you get psychotic due to medical illness? And is it delirium? And she said, well, delirium comes when you have a medical illness. We checked that. He didn't have that. So we didn't think anything of that. And another question, what would a normal process for a safekeeper with severe mental illness be? And she said the same as anyone else, which didn't really answer the question, I guess, which is, what about what's happening to Richard Allen? Because it does seem really different. And then finally, what is the primary obligation of the Department of Corrections for safekeepers on suicide watch? And she said it's the same as it would be for anyone. If it's seriously mentally ill, you need to limit solitary to 30 days. That really, really didn't happen. But I'm not sure if that applies to him because it's safekeeping. So there you have it. And it was a very sort of confused testimony, because it seems like the rules around how he should have been treated were themselves confused. And things got absolutely no clearer with the next witness, Max Baker, who has worked for Rosie for 2 years. He's doing a legal internship. He's the person that they wanted to sit up next to them and stay throughout the trial, because he's doing a lot of their technology stuff, even though he was going to be called as a witness. And each side was given one, and then the prosecutor got a second person as well. So he looked and reviewed all of that video from Westville and the phone calls, just like the state had somebody do that as well. We never actually got to see any of that. He had prepared two different videos and then 2 exhibits to go with them. But let me tell you, this is how the day went. It was nutty. I wrote this out because I thought I got to read this. This is nuts. Let me head back. Did I skip that? Maybe I've already passed it. Give me just a second, because I did really think it was fine. I mean, well, I'll get to it in a minute. Okay, so here was the day. We come in, and the judge says, okay, anything to raise before the jury's in? Nope. So the defense says, call our first witness. They named the witness. Prosecutor, sidebar, please. And so we started out straight off, sidebar. And then there was preliminary questioning, and then sidebar, and preliminary questioning, and sidebar. And then 15 minutes for witness concerns, and then a sidebar. And then the jury came back, and then a bench conference was called by the judge. And preliminary questions were asked again. And then they just broke early for lunch because everybody needed to regroup. It was like a day like that. Okay. So, and here is where we began with a lot of it, with the sidebar. And I have no idea why this wasn't ruled on in advance. I mean, these exhibits have been exchanged. There should have been a ruling from the court that said this is in or this isn't in. It all should have been worked out. But instead, everybody's sitting there on the day of, and the prosecution is objecting, and so they don't have it. There were 2 different videos that he had prepared. The first one, which I thought was just such a good idea, but which the judge kept out entirely. The jury will never see this. What they did was take the 10 o'clock to 2 o'clock p.m. period. At one point, he said 8 to 2, at one 10 to 2. I'm not sure which, but let's say 10 to 2 on the 15th of every single month. And he condensed them and sped them up so you could see what the mental health status of Richard Allen was. That's really important, right? Because it would show the jury, is he deteriorating? Is it really obvious that he is? And is he faking it? Because do we see a huge difference between how he's acting now all day long, or at least for 4 solid hours? Do we see that? Even when he's not in the presence of a guard, he has no one to convince. Are we seeing that? But the judge said, well, that's not relevant because it's not in the period of time when he had mental health decline. I think it was relevant. I think it was relevant to a number of different things, including what the jury is supposed to believe about whether or not he declined. How are they supposed to make this decision if they can't kind of watch it? I thought it was brilliant to put that exact thing together every month. And it was it's not something that he could self-select. It's just the 15th of every month, 4 hours. It seemed to me to make a lot of sense, but it is out. The other thing they had was the walk around during the period from April to July, which was the period when he had the mental health problems in their most severe form. And remember how whenever he had to walked around, he was walked around on a leash and so forth. The audio of that is out. So we will not get to hear that because it was hearsay. Now, Richard Allen could bring in his own statements if he took the stand, but he can't bring in his own statements unless he takes the stand. And so we won't get to hear that, which will severely diminish our ability to evaluate it, but at least we will see that. So we're expecting that likely they have put that together by tomorrow. The reason it didn't come in, because they were going to at least do that, was because the witness was asked by the prosecution, are you sure that all of these only come from that period? And it was a little bit difficult to tell. They had taken the videos and they were sent over by the state as these are the ones from April, these are the ones from May, these are the ones from June. So he said he had put them together like that. And the prosecutor wanted to know, well, are there events in there where you can be sure it's from April? And the answer was no, I relied on what you said when you produced it. So if you put it in the April category, I put it in the April category. And so the judge said, well, I can't let you publish it until you can answer for sure that this is only things that are in the period. And at that point, she was talking April to June, not including July. So we never heard any of that. And they're going to go back to the office, I guess, ensure that that's all we're going to see. And then we'll see that tomorrow, probably tomorrow. It could be later. So because it's only a half day tomorrow. So I don't really know what exactly will be covered tomorrow. There were also 2 videos that were 2 exhibits that were descriptions of what was going to be seen in the video to sort of lay it out for the jury. Like this is, I don't know, right? They didn't show me, but I was assuming it would be things like such and such a date and such a time so that they could kind of signpost it and tell when they moved from one thing to another. So I think that will be very interesting and important for evaluating the confessions and the mental health decline. But I think it could have been much more useful if that one exhibit, that one video had been included. If that we were able to see and watch the decline, I think that would really help people understand whether or not this actually was a mental health decline and whether it happened over the long term and whether it was fate. All of those questions could have been positively impacted if the judge had allowed that exhibit in. But without it, who knows? All right, so all of that took us till after lunch with just a lot of drama going on. We then went into Brad Heath. And let me just say a word about witness after witness today really didn't want to be there, and they were really reluctant. I think this witness less so, but reluctant. They didn't want to testify. There were a lot of objections. It was just slogging through for the defense to get anything out. So this particular witness was a scene witness. He lives outside Delphi. He's age 70, and he was working, at least at the time, for Reliable Exterminators. And he treated a building there not far from the Monon High Bridge. And he talked about seeing a vehicle that day at 8:45 a.m. This is the same vehicle that another witness had talked about. And that other witness believed it was Richard Allen's vehicle. And yet it was an old-timey vehicle, which looks nothing like Richard Allen's. So this person, Brad Heath, remembers the same vehicle, an old-timey vehicle parked in the same lot. It was there at 8:45 in the morning, and it was also there in the afternoon when he went back to service this building, and his scans there were 143 and 206. All that means it can't be Richard Allen. He wasn't there all day. Nobody is contending he was there all day. So it must be somebody else's vehicle. So that was one of the points the defense wanted to make was that Richard Allen, you haven't proven that his car was in that parking lot at that time. Richard Allen says he was at the scene earlier than the prosecution says it was later. So, let's see. All right, next witness, David McCain, also known as Flannel Shirt Guy, I guess by what he was wearing that day. He was the project manager for development of the Monon High Bridge trails. And he entered that day at the Mears entrance, the exact same entrance where Libby and Abby enter. And he arrived between 2 and 3 o'clock. And he was there more than an hour. He said maybe 2 hours. He doesn't know. One of the things he was asked, and if any of you saw my video today about walk with me to the Monon High Bridge, you will know the answer to this. But he said, I don't know if you can see fish if you go to the bridge. One of the things that Richard Allen said he did was he walked to the bridge, went to the first platform, looked down, and he could see fish below, and he just watched the fish for a while. That's how he says he spent the time there that day. And the prosecution has suggested 60 feet up, who's going to see fish? Or at least there's been that implication. So I kind of thought that too. How could you possibly see fish? But if you looked at my video today, I went out there, was like, well, by golly, you could see fish. I was absolutely shocked. It was so clear. You could see everything down below. So I tried to show that in the video. So after we finish tonight, take a look at that and you'll be able to see where you can see the fish. So he said he did take a lot of, he said he didn't know, he didn't look for fish, so he wasn't sure. But he did take pictures that day with his digital camera, and that was important because later they asked him about whether he could have been wearing it with a strap around his neck. And he said, yeah, maybe. He didn't normally maybe do that, but it could have been because he did have a way to carry it that way. One of the other witnesses had seen a man carrying something around his neck. So they're suggesting the person that they saw was this guy. When people talked about seeing a guy wandering around, this was David McCain. This wasn't Richard Allen. Richard Allen was long gone. That's what the defense is suggesting. He said he saw a couple. Lots of people have said that, a man and a woman. That he was surprised at the number of vehicles and people when he got back to the Mears entrance. We know why now. And that's because that was Libby and Abby's family. They hadn't shown up for pickup by Libby's dad, Derek German. So he had looked for them for a while, then called his mother, Libby's grandmother, and was calling her, trying to find her. Like, where is she? Why is she not answering her phone? Why is she not come to be picked up? So he said that he did exactly what Richard Allen did, which is he heard the call that they wanted to know anybody who had been out there that day, give us some information. So he went to law enforcement, said, okay, I've heard about the murders. I want you to know I was there that day. Ask me whatever you want. And like most of the other witnesses, it took quite a while for them to get back to him. When that finally happened, he got a call from 2 FBI agents and a state police agent and maybe a fourth person, and they came to his house to do an interview. And they took the SIM card out of his camera, and he gave it to them. And then what they apparently found, because they came back to him 2 to 3 years later and said, did you notice this? There's a car in the photo in the distance, but he never got the SIM card back. He didn't know anything about the car. He didn't even realize it was in his photograph. He was taking a picture of something different when suddenly they noticed there was a car in the background. So they said, well, we'll get back to you within a week, but then get the SIM card back to you. But he never got it back. The defense kind of implied that maybe these pictures are no longer around for them to see, but they didn't really say that. So I don't know whether they were trying to suggest that or not. We certainly got a lot of information later about information not available to the defense, and this might fall in that same category. All right, let me stop for just a minute and say a few thank yous, because we have tons of people that I need to thank. Baba D is a new member. Wonderful. And thank you, Baba D. Does the jury see the map, including the Logan House location, or is that just your feature? That's mine. They don't see that. However, there is a map, nothing marked on it, just a true like Google overhead kind of map. And they can open it up, and the witnesses sometimes will get up and point to a pointer. One of the frustrating things for us in the gallery is pretty much of the time there's an attorney standing between you and wherever the pointer is. So you're like, where were the bodies? I don't get it yet. So what I've tried to do is put that together from a series of witnesses so that it's hopefully fairly accurate. It would probably be helpful for the jury to have all of that, but they are getting somebody with a pointer, and they'll sometimes can make the map bigger, narrow it down so you can see everything. So it's pretty fancy. It's a very, very large computer screen, and it's pretty impressive. Thank you, Cosmic Crumb. I appreciate it. And Donna Panoni is a new member. And hello from Glengarry, West Virginia, says Jason. I'm glad you're watching all the way from West Virginia. Thank you so much. Jeannie Three Wishes is a new member. And Neurosite Zena has been a member for 5 months. Thank you. I appreciate it. Thank you very much. Well, I'm going to stop right there, and I am going to keep going with our description. So this witness saw a man coming across the trail onto the Mears property, a large man in a bright orange jacket, portly, and he didn't know how tall he was, but he could see, and he couldn't see his face particularly well, but this man shouted a question to him. And that question was, have you seen 2 girls? And the witness said, well, I got the impression that he was looking for them. And the man was concerned. He got that impression as well. So this was important, I think, to the state, to the defense. It supports what Derek German said. It supports that Derek German was looking for Libby and Abby at this time, and they were already missing. And also, of course, this is really important for the defense, this witness is, to showing that maybe the person that people saw is this guy, not Richard Allen. So maybe Richard Allen's time frame is right and fair, and maybe this guy was wandering around and nobody believes he's the murderer, but people saw him and they got him confused. They called him Bridge Guy. They didn't, and they had wildly different descriptions of who exactly Bridge Guy was. So maybe it was really this guy. That's the point that they're making. Maybe it was David McCain. Let me make sure that I have covered everything about that. So he was pretty vague with his times. Like he could have arrived at 3:15 or it could have been 2:30. He was just pretty vague, but he did have that possible camera, which one of the witnesses had said. Next witness, Daryl Sterrett, and we burned through the witnesses today, age 57, and the fire chief. He was at a training event that night, February 13th. Lots of people were there. They were doing some training. And at some point, the message came through that they had 2 missing juveniles and that they were requesting help with the search. So he rounded up everybody present there and probably some more people who came in, and they all went looking for Libby and Abby. They set up there was a joint command post set up. He said the 2 people in charge of it were Sheriff Tobe Lesenby and Steve Mullen. We're about to hear from both of those coming up next. He said his firefighters, waited at the station. But a group of them, first they searched the town. Who were Abby and Libby's friends, and had they seen Abby and Libby? And maybe they would have some clues, pictures from Snapchat, or maybe one of the girls had said, yeah, we're running away, just something that would give people a place to start and begin looking. But after a while, they then went out to the area around the Monon High Bridge where the girls were last seen. He talked about, and I'm going to add this back to the stage so you can see the creek running there through the middle, right? So slightly below the middle, it curves like crazy. That is a really curvy creek. So what he explained was he took that road leading to the Weber home. Its road is generous. It's a driveway / path, gravel. It's not paved. Certainly not by the time it gets down to the Weber house. It's just a dirt path. And so he took that, and then he and the people he was with searched kind of near where the clothes are, right up to the bridge and in that area. The bridge is actually pretty long. It's spanning a 60-foot deep chasm where the creek is. And so it goes back into the woods. I can't say for sure, but probably ends maybe about where the sea is and close, maybe not quite that far, but it goes a ways. So they were looking around in that area. They were not looking across the creek. Ultimately, the bodies were found across the creek, but that wasn't where they were looking that evening. He did say, and he said they were concentrated sort of in that area, maybe even south of the bridge and to the west. They weren't looking specifically. And this began a long series of witnesses where over and over again, they were challenged. Well, did you say this in your deposition? And over and over again, they had to acknowledge, okay, yeah, I said that in my deposition. And it was different from what they were saying here during the day, what they were saying at trial. So in the deposition, did you state you were only on the east? He said, well, I might have, but I didn't have a map then. So, and then at his deposition, he stated that he left the scene about 2 or 3 a.m. He had said something different. And then he said, okay, about 2 or 3. And then the deposition, he said it was 2:30. And he was asked, did you order a search of both the north and south of the creek and east and west? He said, I searched on the east side of the bridge. And then the deposition said he ordered it, all of the above. Were there floodlights? He was asked. He said, well, possibly we had a vehicle out there that could have had brighter lights. And I'll explain why any of this is being asked in just a minute. And they want to know who else was out there besides the fire department and police officers and the family. And he said, well, I'm not really sure if any citizens were out there. They went back to the deposition, which said, yep, there were other people there as well. So this happened kind of over and over again. Here is why this matters and why the defense is doing all this. They want to prove that the bodies and the clothes in the creek weren't there when everybody was looking around, that people were tromping up and down all along the creek, and they would have found the bodies had they been there. That's what they want to show. And therefore, they're saying the bodies did not get placed where they were. The girls weren't murdered, and they weren't murdered in that area until sometime the next morning when they called off the search at 2 or 2:30, and they didn't start again until 6 or 6:30. That's the time frame, they say, when somebody brought the girls in there and killed them in that clearing about where you see the X for bodies, somewhere in that location. Somehow during that time frame, clothes got dumped in the creek. So all of these questions are aimed at getting the witness to show the jury that there were lights, They had flashlights. He said they even were going along the creek with their flashlights. They saw no clothes. They saw no sign of the girls, and they didn't see the bodies. Now, there was pretty successful testimony the state offered before that if the bodies were, well, not if, the bodies were where you see the X, and that could not be seen from the other side of the creek. It just wasn't visible. So they could have not seen the bodies while the bodies were there, no matter how many lights they had. Just the angle wasn't possible. But the clothes, they well might have seen. And furthermore, one of the things the defense wanted this witness to say and got him to say was that there were lights on the other side of the creek. So where they're looking, they're seeing flashlights walking around in the woods on the other side. And what the defense wants to say is, even if these particular firefighters weren't over there, other people were. That's how we know the bodies weren't there. That's what they would like to argue. All right. So were you looking in the water? And yes. Did you see anything floating? He said no. Were you able to hear people across the creek? And were you able to hear noise? This was pretty funny because he had been impeached over and over again from his deposition where he would say, no, well, let me refer you to page 52. No, let me refer you to page 85. And so he said, were you able to hear people across the creek? He said, I would say no. What page? And everyone burst into laughter. I did see a group of male jurors sitting in the back, and they were talking a lot during this period, kind of talking back and forth, some notes. And I really do think that what they were saying and suggesting, well, I think they were responding to the fact that he couldn't remember anything from his deposition, and it seemed to be kind of a problem. And in fact, the juror question, and by the way, could they hear people in the other area? The answer was yes. That came from his deposition. So one of the questions, which I feel sure came from one of the three in the back, was, how long ago did you give your deposition? And did you get a copy at that time? And the answer was, and I was assuming, it must have been, maybe it was a year ago that they deposed him. And although it is hard to explain why he would have forgotten everything, he would have remembered for 6 years everything, and then in that one last year, he forgot what he remembered for 6 years. It turns out he was deposed 3 or 4 weeks ago, and he was given a copy, which was mailed to him 2 weeks after. So I thought that was pretty perceptive question by the juror. All right, and we move to one of the best witnesses of the day, Steve Mullen. Now, we have heard from Steve Mullen, I guess this might be the 4th time. They keep putting him up for a little something, and then they'll put him up for a little something more on the prosecution side. He's one of their witnesses allowed to be there the whole trial, even though he's going to testify. So he's heard all the testimony. He knows what's been said. And it was just a great examination. How important is it to preserve evidence in a case? He says, to preserve evidence, that's important for everyone. And Baldwin for the defense says, well, how important is it to alert the defense of missing evidence? He said, that's important. Yes. He said, why? I don't understand the question. What do you mean you don't understand? Why is it important? So he says, why is it important? And the witness said something to the effect of, it's an important question. And Baldwin, thank you. And very deadpan, thank you. And he said, so why is it important? He said, for the integrity of the investigation. And he said, what evidence, if any, has come up missing in this case? And there was an objection by the prosecution, and I am calling this one out. I am calling this one. I don't call out lawyers. I do not on this channel. But the prosecutor's objection was, what case? Allen's case? What do you mean, what case? The murder case. He's charged with murder of these 2 girls. It's the case, the entire investigation into the murder of Libby and Abby. What do you mean, what case? And the defense says, the investigation of the deaths of Libby and Abby. And the prosecutor objected that it was not relevant. Like, what? How can the investigation of the murders of these 2 girls and he's charged with their murders. How could that investigation not be relevant? But the prosecutor argued it was not. So he's trying to keep the information about the missing evidence out. And some of that missing evidence would have involved searches into other people as well. So when they're talking to a particular witness, maybe that witness, well, none of the witnesses were talking about Richard Allen, but they were talking about someone else. But the fact that the witness investigation, the witness statement is missing, that still matters. That's 100% relevant. I can't even believe that was an objection, which was entertained, but they had a sidebar. The objection was objection not relevant, and the defense, sidebar, please. yeah, let's have a sidebar on that one. And so they came back and they kind of changed the questioning around. But I'm saying again that the investigation into the murders of Abby and Libby could in any way not be relevant to this case is just beyond my understanding. I don't get that objection. So, and I will say this too. One of the things that I think savvy prosecutors do is be really careful that they don't push the line too far, because if they have a judge who's very favorable to them and they get too many rulings, they may take the case into the now it gets reversed on appeal stage. A prosecutor doesn't want that. A prosecutor definitely does want to win the case. They brought it because they believe the person's guilty, but they want there to be a solid case. They don't want anyone ruling that it has to be overturned. It has to be tried again. They don't want that on appeal. So the next question was, are there interviews that the defense does not have because of the information going missing? Objection, leading, but ultimately he was allowed to ask that. And the witness said, yeah, but it's not available to the prosecutor either. And so this is what's missing. And it's staggering that this is missing. From February 14th, the day that the investigation began, for over a month until March 21st, 2017, dozens and dozens of witnesses, and the interviews are just gone. They're just missing. They don't have them. Those are, of course, the most important days, because you're getting people's first memories. And with time, people forget things. And these witnesses, dozens and dozens of them, they don't even have a list of who is missing. He said, what list was drafted of who's missing? He said, well, there was a list of interviews in a filing cabinet. And he talked about the fact that they did not do anything to recreate the interviews that they were missing. There was nothing they could do by the time they realized this in August. So all this time has now passed, and they don't know how to recreate it. Baldwin said, or whoever was asking this, could you go to John Doe and say, we lost your interview, let's redo it? And he said, well, I didn't. The investigative team made decisions about who to go back to. But there are no telling how many people there were, like Richard Allen or David McCain, who went to the police and said, hey, I just want you to know that I was there, and I may have seen something, but those are now missing. Who was re-interviewed? He said he didn't know. He thinks someone was, but he doesn't know who was re-interviewed, even though he is one of the two investigators in charge of the entire investigation. And he said, without looking at notes, I just can't answer your question right now. He said, well, why did you re-interview some and then not re-interview others? He said he can't answer that. One other question I have, even though we're being told there are no interviews for that period, we do have notes of what Richard Allen said to Doolin, the person who interviewed him. So I don't fully understand what it is that's missing, because it seems like there are some pieces from this investigation that are present, because we know Richard Allen was interviewed something like 2 weeks into it. We know same for David McCain. They apparently interviewed him as well, and they have some notes from what he said. They came back to him. I guess we don't know for sure they have the notes from what he said, but we do know they knew enough that he had been interviewed that they came back to him. So at this point, he talked about a second group of interviews also missing, and that they had problems with their DVR and lost videos. And that they were able to recover the videos, but not the audios. And he said, well, was there a list made of the people in those interviews? And he said, well, for the most part. And he said, you know, you have the same interviews we have. You, the defense, have the same interviews we, the prosecution, have. And I think it was Baldwin, said, well, all interviews are valuable, right? And he said, yeah. But he said, well, it would probably be more valuable if it had the audio. And there was like this audible snicker from one of the jurors at that point, because it's like an interview without audio. I mean, all you can get is the body language only. That's all you have. So unless someone is looking highly suspicious, guilty, and sketchy, you got nothing, right? You don't know what they're saying. You have no idea the time frame or any of the facts that they're giving you. You maybe can tell who the person is if the people know each other and can say, yeah, that's so-and-so. But he also did reports on these things. The witness did, Steve Mullen, and reports that cataloged what exactly, we have discovered some information is missing. This is what I found. And he said, but he didn't put any dates on those. And Baldwin was suggesting, well, without the dates, this is really not very reliable, what you've written down. And do you know when the missing videos were disclosed to the defendant? Objection, speculation by the prosecution. Judge says, if you know, and the witness says, I don't know. If you know from the judge means feel free to say don't know. That's one of the things that it cues a witness in, is you don't have to know the answer. So that's kind of how it went. So then the question was, well, was it several months to a year later? And the witness said, yeah, actually, over objection, said, yeah, it was pretty close to that. And said he didn't think it was sloppy to have left the date off the report, but he did admit that if he'd known, he would have dated the report if he had realized it was going to be a big controversy and that the defense would want dates on these reports. One of the things they're trying to show is this is when you did the report and you didn't tell us about this missing chunk until later, till substantially later. You knew it, and we were operating without any information about that. And we got into Brad Weber, and boy, this was intense. That Brad Weber was interviewed in August of this year, and you called him on the phone to bring him in to talk about whether he went straight from work home in that van. Could that fact that Richard Allen spouted out in the confession, could this be true? And could it be the cue that these confessions were real? Could this be a fact only the killer would know? That he was interrupted by a van, and that van is what caused him not to R the girls, no SV, but to kill them. And because he threw that out in the middle of this confession. And the prosecution is saying we had a lot of facts in there. Maybe he had seen in discovery pictures of the bodies. Maybe he knew how they had died. Maybe he knew where they had died. Maybe he knew some of those facts, like that there was bridge guy video, but he couldn't have known that a van was coming along. So let's see if we can prove that. And that's what they were trying to do. But he made this phone call to the witness, but he didn't memorialize it. He didn't record it. And so he said, if you had it to do all over, would you tape record it? And he said, obviously, probably I would. And then there was a really interesting segue, because he said, well, okay, what about, did he say that he went to check his ATM machines first? Objection, leading, etc. And then they kind of went around it a different way. Are you aware if Brad Weber had a side job? He said, yes, he did. He had some ATM machines. So the jury has to be sensing that the defense is closing in on this slowly, little bit at a time, creeping handhold by handhold up the side of the mountain. And he did point out what kind of gun did Brad Weber have, and it was a Sig Sauer, and they tested it. And he said, did you or law enforcement, he went off on a little segue here, make a list of the law enforcement who walked in and around the area where the body was found? He said, I don't know. Did you do some emails to law enforcement who had been there asking what weapon they were carrying? And then, are you aware of information where law enforcement believed that unspent cartridge that was found nose down in the ground between the feet of Libby and Abby could have come from law enforcement gun? And that was one of the things they wanted to prove, was that law enforcement could have dropped that .40 caliber it wasn't necessarily connected to Richard Allen. It's one of the most important pieces of evidence for the state. The state says ballistics testing proves that unspent cartridge matches fingerprint light, glove light to a gun they found at Richard Allen's house. And then there were some interesting questions. How many people do you think were involved? It's a question that people have struggled with since the time. Oh, I should be way out of that map. Okay. It's a question that people have struggled with since this happened. The crime scene is really complicated. There are sticks lying on top of the girls. The girls are clearly posed. I don't care what they say. They clearly are posed. You don't have to believe in Odinism to believe somebody put this body here and this body there and put them there. But, and you can see that by where blood is. I mean, it's just clear that even now they admit that the bodies were dragged there. So he said, well, he now believes that one person was involved. How long have you believed only one? Since the arrest of Richard Allen. So up until then, he wasn't sure at all that it was only one person. And they asked, because before that, you thought there were multiple people. He just said, it doesn't matter what I think. He didn't really answer that. But the implication is that he did think it was more than one. And the question, a lot of stuff was done at that murder scene. How long would it have taken for Richard Allen to do all of those things? And remember how unbelievably little time he has, because at 3, well, we'll pull this up. Thank you, Neurosite Zena. I'm going to put that down for a minute. Okay, so we've got the last movement of Libby's phone at 2:32. We've got Abby lying on top of the phone, and nobody believes the phone was ever moved again. And Abby's dead on top of the phone, or dying on top of the phone, but she's right there. And so that means 2:32. The crime has been committed. At least one of the girls has been killed by then. And it's just a brief matter of time until Libby is killed too, or maybe she's already dead. No one really knows the order or how that would have happened. But what law enforcement is saying is that he says he left the trails at 3:30, and that seems very possible based on everything else that they have. But how all this could have happened that fast, that means he had from 2:32 to 3:30 to stage the bodies, make sure they were dead. He said he waited around in his confession and make sure that they were dead, and then leave the park by back trails and get out of there. There was also a sighting of the muddy, bloody man. I believe that was at 4 o'clock. I'm pretty sure 3:57. Yep, 3:57 is the sighting of the muddy, bloody man. So there's not a lot of time for this entire crime to be committed. And the defense is saying it must have taken more than one person. This doesn't happen that fast. It's just not possible. All right, we're going through the testimony of Steve Mullen. It was some of the best testimony of the day, most interesting by both sides. So he then got into some questions. I'm going to have to put the timeline back up. But when he got down the hill, how far was that? And when he ordered the girls down the hill, and was it at least 10 feet? And the witness didn't really know. And he said, well, if you went down another layer, just down the hill, you went down to the creek, that would be another 10 feet, right? And he said, well, I don't know. Why does that matter? Well, we will head back into this and take a look at the data from Libby's phone. So at, let's see, we'll skip Libby's, the video of Libby was at 2:13, the video of Bridge Guy. Let me go ahead and arrange everything. Okay, then they're abducted right in there, 2:13. At 2:14, her video stops. We don't get any more video from Libby, although somebody tries to unlock the phone with probably face or something biometric. It says maybe a fingerprint. Then from 2:25 to 2:31, Libby's phone moves 68 steps. Now, that would possibly be moving down the hill. But what we see is from 2:31 to 2:32, her phone registers 2 floors. And seeing the video, you can see down the hill is pretty steep. it looks like more than 10 just to get down to the road. And then there's another level down to get to the creek. So what they're saying is, what the defense is suggesting is, that doesn't match up with Richard Allen killing them by 2:32. How does this even happen? So all they've done during this period of time is move 68 steps and 2 floors. And somehow during this period of time, doing nothing more than that, they managed to get all the way down that hill, down to the creek, move down a ways, across the creek, up the hill on the other side, and into the clearing. So the defense is using, I believe, I think they'll, I mean, I did this timeline. This is not their timeline, but I'm saying, I think this is the point they're trying to make. I'm trying to explain what I think they're arguing and how they think the timeline is helping Richard Allen. That's one of the statements they made in opening. This is what I think is what they mean by that. And so they asked the witness some important questions like, did that phone ever leave from being under Abby's body? No. Did Richard Allen leave with the phone? No. And they did ask the question this time. Another witness, maybe it wasn't Mullen, was asked, did Richard Allen ever return to the scene later that night, say? And the first witness said no. This witness said, I don't know. On the 13th, were you aware of any search members within 100 yards of the girls, was another question. And it turns out, and he talked about trail cameras that were right in that area. And the trail camera, he said, would it refresh your recollection to answer a question? He goes, no, I recall what I told you. Baldwin says, I don't think you do. He showed him the testimony anyway. So and we'll get to the trail cameras more with the jurors, because boy, were they interested in those trail cameras. They were all over what happened in the trail cameras, but I'll get all mixed up if I try to skip to that. So let me finish with what he said. He said, all those tips you got, 14,000 tips. How many of those involved Richard Allen? And the answer was only one. Now, he said it wasn't a tip. It was information from the girls on the trail. But really, the only tip of those 14,000 was Richard Allen turning himself in the sense that he said, I was there that day on the trails. He asked, why did it take so long for Unified Command to get Kelsey's DNA profile and turn it over to the lab? And he said, I don't know. All right, let's see. He also talked about, remember, the witness who said that he believed that Richard Allen's voice was the same as Bridge Guy's voice. He said, well, did law enforcement receive many tips about people who recognized the voice and claimed, oh yeah, that's my brother-in-law, that's my neighbor, that's my ex-husband? And he said, yeah, in fact, they had received perhaps hundreds, none of which were that Richard Allen's voice matched Bridge Guy's voice. I don't even think it's possible. It's so computerized, mechanized, because they've done all this stuff to enhance the sound that I personally don't even think there's any way to connect it. So he said he did not know whether Richard Allen had returned to the crime scene. Then on cross, they moved into the Brad Weber, and he stressed that I didn't tell him what I was going to ask him about. I just asked him to come in and talk. I didn't tell him anything about it. And he said that he drove his van home and that he knew that from phone records. He said, and you pulled those records and you confirmed that he drove home. Ah, there goes the light. Give me just a second. Oh. And so I can go ahead and tell you what they said. I don't know why it's not right here. I'll just go ahead and talk about that. And then when we get to it, I'll skip that part. So then the question was, so you didn't tell him what you were going to talk about, and yet he did this research on what he was going to say and on this topic before he got there. How did he know what to research? And the witness's answer was, I'll have to get it. I agree, and I have no explanation for it. Well, that's clear. I have no idea how he knew that. The implication the defense wants to make is you told him that, and so that's why he's coming in. Remember, they believe from an FBI report that was made closer to the scene, to the time of the murders, that Brad Weber did something else entirely that afternoon, that he did not get home, that this proof that a van drove by and could have startled Richard Allen, and that's the one fact that he added in his confessions that only the killer could have known, that's a fake fact. If the defense can eliminate this fact, it means that there are no facts in those confessions that only the killer would have known. It's only facts he would have received in the discovery. We also think, based on a statement from the defense, that they're going to say that there were hundreds of references to the van in the discovery. So Richard Allen could have seen it anyway. But that's why this pitched battle over something so small as whether or not this guy came home between 2:27 and 2:30 in his van. That's why it's every bit that important to establishing whether or not Richard Allen's confessions are real or not necessarily real, instead influenced by his descent into mental chaos as a result of the way he was being treated. All right, so Brad Weber also had that Sig Sauer, which was not excluded, as he pointed out, as I guess it was Baldwin pointed out, said it was determined it was not the weapon, says the witness. That is not correct. As he pointed out, that is not what was said. What was said was that it was inconclusive, but then the witness, the ballistics expert, said, well, now having seen what the match of this unspent cartridge at the scene looks like compared to Richard Allen's gun, if I had it all to go over, I would definitely go back and change what I had said. I would never say that Brad Weber's gun was inconclusive. I would say it didn't match at all. But in truth, what was said initially, inconclusive. I don't know. Could match, could not match. I don't have enough to be able to tell. All right, but the jurors, they wanted to know all about that trail cam. Tell us about the trail cam. Trail cam. We do not have trial cams in this case. In fact, it's one of the things missing about this whole case. We need trial cams. Instead, trail cams, which didn't show all that much. They were facing, here, we'll pull this up. They were facing, see where the bodies are. They were facing down to about where the word close is. That's the direction they were facing. So do you see where the ditch ravine is pointed out? They were to the left of the ditch ravine, away from the bodies. And then they were pointed kind of in that southwest direction. So they weren't facing the bodies. It was the opposite of that. So the witnesses wanted to know all kinds of things about that. Is it possible to see anything on the ground? Could you have seen bodies? Answer, no. Did you saw someone on the trail cam, and what were they wearing? And the answer was they identified the person. It was hilarious because everyone in the courtroom heard something different about who was identified. I heard the word fireman and then a word. And no one, I thought at first no one else had heard that. But then I talked to the court TV reporter, and she heard fireman too. So I was like, aha. So I don't know. Maybe it was. I figured if it was a fireman, they were saying we were able to identify that he was there doing the search that night because he was with the fire department. And that's how, oh, dang it. Am I running out of power again? I almost did that last night. I've got too many things plugged in over here. Okay, there we go. We're safe. So I figured maybe that was how they knew that they didn't have to conclude that this person was involved. This was somebody out there searching in the evening. But since it wasn't specified, we were just left guessing until the audio comes out sometime much later than that. Here is another witness. Another juror question. This juror is very focused on the timeline. Super interesting. And I don't know which juror it is, but Libby's cell phone stopped at 2:32. Do you believe that is when they died? And he said, I do. And we know why that's so important, because it really makes it almost impossible for Richard Allen or any one person to have committed the crime between 2:13 and for them to be fully dead in under 20 minutes. Wow. And it's not like they're in the same spot. They've gone down the hill, gone through the woods, let's think what they have to have done. They have to move from the Monon High Bridge, even pull it out into the woods a little bit. Assume they're out in the woods. They've got to cross through the woods, change clothes, because their clothes weren't necessarily bloody. The clothes that were on Abby weren't necessarily bloody. So they've got to change clothes. Clothes get put in the creek at some point. They cross the creek, all three of them. Then they go up that hill to where the bodies are, and they're killed. And all of that happens in under 20 minutes, in 19 minutes, in fact. That is really fast. That is a very, very short time frame. But that is what the prosecution is saying. So we then had Sheriff Tobe Lesenby. He was the sheriff at the time. I guess he's former sheriff now. He's continues to work there. He's the Carroll County Chief Deputy right now. He was asked, how many individuals do you think were involved? And he said, well, initially it was unknown, but after Richard Allen was arrested, I felt it was one. Major impeachment. Let's go ahead and talk. Major impeachment using his deposition, where it said, well, didn't you tell me in August of 2023 that you believed multiple or at least two people were involved in the murders? And that's hard to explain if it's just Richard Allen and it suddenly happens on the afternoon and who knows where he came from or why. He had no intent or plan, had no idea the girls were going to be there. And yet in just 19 minutes is able to do all of that. So the defense has done a decent job of showing that law enforcement was really leaning toward the idea that there more than one killer was involved. He named another person, now Sheriff Liggett, who believed that there was more than one person involved. So that's now three people who at least at one point believed there was more than one person involved. And he was asked, well, why? Why did you believe that? And he said, because of the totality of the information available to investigators and the bigger picture of what happened at the scene, which is what the defense is arguing. McClellan said, well, you weren't heavily involved in the investigation, were you? You didn't know all the details. No, he didn't. But then the question on redirect was, well, you were the sheriff, right? You were the sheriff in 2017, 2018, 2019. And he stopped him. He said, I was sheriff all the way through 2022. So through this long period from the time the murders happened for at least 5 years, he was the sheriff. So by all means, he was completely on top of everything that happened in that investigation. I don't think anyone doubts that he was following it very closely, and he was convinced it was more than one person until 2023. One of the jurors asked, how many murders have you personally investigated in your career? And he said he'd been involved in small ways, but not personally investigated any, which was an interesting question and answer. And now we are going to get to something that's going to sound complicated, but it's really not. We're going to talk through it. So remember that they wanted to that the defense wants to put in that report by the FBI. Brad Weber is claiming he drove home between 2:27 and 2:30 in his van. That would fit with Richard Allen's dream, confession, whatever you want to call it, with his confession where he said that he was planning to R the girls, but he did not. He did not. Instead, he was interrupted by a van that caused him to panic, and he decided he had to kill them. And that's why he killed them, that it wasn't an intent. He instead had intended to SV them. That was his plan, such as it was a plan. It was a last minute thing, but that's what he says in his confession. So the prosecution thinks that one fact that sticks out is that van, because where'd that come from? So they think now they've proven that there's a van there. The defense wants to say, we think the guy who claims to have driven the van there between 2:27 and 2:30 is lying. We think he told the FBI at the time that he went and did a bunch of other stuff that afternoon, and not until much later did he come home. So he wasn't there between 2:27 and 2:30. So there was no van. The entire confession is made up. It's not some secret fact known only to Richard Allen. And so, and known only because he was the killer. So the problem is, as you heard that first witness said, looks at it and goes, yep, I've had my recollection refreshed and I have no idea. I don't know what else he would have said. As far as I know, he went straight home. So they don't have that in, right? They don't have that in. They got another witness. They got pretty close. They got at least the witness to admit that this guy owned ATM machines. But they're sitting there looking at that initial report, that interview by both the FBI agent and the man who testified today, whose name I am blanking on, but is Christopher Goatee. So they're looking at that report and they can't get it in. So they argued, and let me explain, they're requesting it under TUI. That's the name of a case. And there's a procedure set up for how you get a deposition of a federal employee, FBI agent, et cetera, or how you even get documents. But in this case, the deposition or testimony of an employee. And so, and it's not that easy. And you can kind of see why. The federal government doesn't want all its people out giving depositions all the time, appearing at trial, because then when will they ever get their jobs done? So they make it pretty difficult to get testimony from a federal employee. It's not that easy. And you have to jump through some hoops. And one of them is you have to show you can't get it some other way. Well, they have now proven that pretty much, because they have tried with several witnesses, with Weber, then they tried with Goatee, and they got a little bit in through the witness who said, yeah, but in any event, they're not there, right? They don't have this in. So they want the FBI agent to come and to say, yes, here's what I wrote in my report. And what I wrote is that Weber told me, and it's refreshed my recollection, that Weber told me he went out and serviced his ATM machines and he didn't come back until much later. So the problem is, according to what they told the judge, that the supervisory special agent Pohl is in command of elections in Texas. Bad timing, right? And had another issue, a medical issue, which they didn't describe, but which prevents flying and might prevent even driving. And Rosie said, well, I've talked to another judge here in the county in Carroll, and he's willing to come in, even though it's Saturday tomorrow, and to facilitate the testimony. And we're asking to be able to do it by video to allow him to appear. Now, if you're not in the legal community, you would be like, so why are we hearing about this? Well, it's because for lawyers, this is newfangled. The very concept that you would do anything by video. That's not how we do. We haven't done it that way for the last 100 years. And we certainly wouldn't want to begin to change now. And I tell you, I wrote some about this around my, when we moved into doing mediations for the first time by Zoom, and lawyers, I did a poll and lawyers completely agreed. We would never have done this had it not been for COVID. Oops, I've said that word twice now. Anyway, hopefully it's no longer banned. So, but in this case, the judge is ruling that they can't do it. Let me tell you kind of how it all worked out. She said, first, you had the evidence in August, but you didn't issue the subpoena to him until 3 to 4 weeks ago. But I mean, if he's in charge of elections in Texas, that seems like a pretty big responsibility. So I don't know that that would have helped. But in any event, and besides, issuing it 1 month after you first received the discovery doesn't seem like that long. Depending on how much discovery it is, it might take you a while to go through it. And the state said, well, you should ask Weber, and you never asked Weber the right question. You never said, did you tell the FBI and this and the other witness, Goatee, that you came home not between 2:27 and 2:30, but instead you went out to check your ATM machines first? I felt like Baldwin did ask that, but I'm going to go back through my notes. The prosecution and the judge were saying he didn't really ask that. That was how I remember it coming out. And the last part of the deposition was Weber yelling, no. That's the part I remember. Maybe it overshadowed everything else. It was such a surprise, but I thought he asked that. The judge said, well, he wasn't confronted with that, but the judge ruled not based on that. Even worse for the defense. She ruled that she ruled that they had not given enough reason or proof to be able to do this by technology. She said, I understand there is technology, but I haven't heard that good cause was shown. Now, many of you would be like, why would you show good cause to just show up by video? I mean, people show up by video to everything all the time. Why is this such a dramatic thing, and it's not in any other industry. But that's what the judge ruled here, was they hadn't made a showing that would entitle them, that he couldn't get here. As being in charge of elections in Texas, that wasn't enough. Being unable to fly, that wasn't enough. So they need to bring him here. That may well prevent them from bringing this witness. I don't know what they're going to do. It's a real big problem for them, because I don't know how they overcome that. But she did it on if she had ruled the other direction, if she had ruled that the way that they hadn't asked him the right question, or she had just ruled that, no, I'm not going to let you do that, I'm not going to let you come in on Saturday. Maybe she'd ruled straight up, but because she ruled that they hadn't made a good enough showing to get somebody by video, that's going to be almost impossible to overcome on appeal. I think that's the kind of thing that an appeals court is going to go, that's way too small. Yeah, we're not getting involved in that. So I don't know. That could really prevent them from getting this witness. And as I mentioned, this is a really important witness. So we will see. What will they be able to do? They may well call Weber and ask him that question, but I can tell you that he's going to say he didn't check his ATM machines. I felt like he answered that last time, so I can't imagine he's going to change that answer now. They asked again. They want that Odinism in. They really want that in. And they've argued that there have been a couple of times the door has been open. One was by the admission that sticks were laid on top of the girls, and it was kind of weird. There is also that statement by a man named Elvis Fields, who told an officer, well, if I spit on the girls, but I had an explanation, would I still be in trouble? So that was, and he was connected in some ways to Odinism. The judge reiterated there is no nexus to third-party suspects in this crime. What she's saying is, you haven't established that these third parties are connected to this crime. That is probably the biggest appellate issue available for the defense team. That's very important. We've talked about that before, but she reiterated it. So Odinism still not coming in. Third parties still not coming in. They are going to be going straight up with just the Richard Allen didn't do it. That's pretty much what they'll be limited to. So how long will trial last? I don't know. I do not know. All right. Well, I think I have finished my notes. Go ahead and place your guess for the number of pages. So let me know what you think. I'm curious how many you think, and in just a minute, I'll tell you. But first, let me thank a few people. All right. And I'm trying to remember where we were. I don't want to skip anybody. I think we were looking. I don't know. I don't know where we were. Okay. Well, Info Nerds, Ruth Ars, and Baba D are all new members. Super glad to have you. Oh, I think it blinked, so I may have lost some. And my apologies if I lost yours very much. Oh, you asked about the map. I remember there's Neurosite Xena. Here we go. Okay, so I hope I don't miss anybody, and my apologies if I do. Okay, Summer Dawn. Have I ever had a judge that wouldn't let you use your client's defense? And is that grounds for an appeal? It's definitely grounds for an appeal if you aren't allowed to put in some of your important evidence. Remember, appeals rarely win. I know that people, have in mind that, defendants innocent until proven guilty, and they have in mind probably that appeals get overturned. The stats do not bear that out. I clerked on an appellate court, and so I saw it's a very high standard to get a case overturned on appeal. So absolutely, it's grounds for an appeal. Is it a sure winner? Not at all. Michael, member for 7 months. That's great. Thank you for reminding me. We have a members only stream tomorrow night. That'll be after our regular stream. So tomorrow night, I'll be breaking down what happens in court during the day. We'll cover that at night. And then after that, we'll do a members only stream and just chat and talk. One of the things we're going to do, I'm going to give you some background information. I'm going to describe to you where everybody sits, what everybody wears on a regular basis, what they look like. And I thought that'd be kind of fun, kind of interesting for y'all to hear more about the stage, the characters on the stage, and who's doing what. All right, Paige and Hippie Chick and Hippie Chick are new members. And April Osteen has gifted a lawyerly membership. Thank you. And somebody be sure you've turned on your ability to receive a membership, because that'll be, you can't get the membership from YouTube. They randomly select, and you can't get that until you turn that on. And Indie Girl, thank you for gifting 5 lawyerly memberships. I appreciate that. We'll have more the merrier tomorrow, right? And Watton Our Nation has been a member for 4 months. Thank you. And will Walla face any consequences for poor ethics? One consequence already is that she's not allowed to work in the Westville Correction Center. Will there be other consequences? I don't know. But the fact, and I don't want to go so far as to say poor ethics, because I don't really know all the ethical rules around her job and what she's required to do. I do know that Westville was displeased and very upset that she had used, I guess, her passcode or some access she had to look up another inmate who was not her patient. And I know they were upset about that. And she talked about that on the stand. Indie Girl, thank you. Paper Chaser has been a member for 8 months and feels bad for Kathy Allen. That would be tough. She was out of the courtroom for a while today. I think she was not going to watch the video that they were going to do that was going to show sort of the mental breakdown, but she was back in the afternoon, and we haven't seen that video, and no one is going to see that video. So we will see. Puff Puff, thank you for the super sticker. Tommy Cool, I am just really thrilled to be here. I'm so glad that you are watching. Thank you very much. And Devin Williams, Jan Shore, and Dan Worley are all new members. This is great. We're going to have a really good turnout tomorrow. It'll be a lot of fun. Kelly Ratliff, we're going to stop for a minute and go over and take just, well, let me go through here because there may be a lot of questions in here. Lauren D, thank you so much for the super sticker. I appreciate that. Y'all are just being nice. You have no questions. Moonlight Dance, thank you for all you're doing. I appreciate that. It's definitely been something wild and crazy, not at all what I expected. Everything about it has been different, but it's really fascinating to see the case unfold and to watch the facts come out and see how the lawyers interact and just to observe. It's been fascinating to see. This is one wild case, and it has so much to say about our legal system. It has so much to say about the mental health treatment, the treatment of prisoners. It's got a lot of meat to it in the sense that there are issues that we ought to be thinking about as a country, as a community. These are important things, including getting the right person and convicting the right person, whoever it is who killed Libby and Abby. That's really important. I think any of us would agree with that. Mitt Spunky, thank you so much, has been a member for 6 months. That's great. Thank you, Mitt Spunky. Polly asking me, does Richard Allen have his wife saying he got home at a certain time? I've not seen anything like that. Proof of the time he left the bridge. I haven't seen anything like that. Even online in rumors, I haven't seen anything like her saying that. I don't know where she would have been. Does she work? Maybe she wasn't there. I don't know. That's a really interesting question. What's the Obsession says, it's not clear what justice is for those precious girls, but your attentive eyes and ears are a critical part. And that is exactly why I came, because the idea that this would sort of be behind a cloud of secrecy when it does appear that there has been mistreatment of Richard Allen, and that is not justified by the fact, even if he murdered the girls, that we're super angry about that. It's just things we don't do. And that's why they have the rule that you can't be in solitary confinement more than 30 days, is because they are trying to keep people from breaking down mentally. And if that then was used and coerced confessions that are false, that has unbelievably terrible implications for what's happened here. So it's really important that there be oversight, that there be people who report on what's happening. This can't be allowed to happen. And that's why I am not even saying it has happened. We have yet to have seen all the evidence and won't see all the evidence that the defense wants to put in. But I will definitely report on everything that I see when it comes to when he's walked around, the walk-arounds, I think they call them. I'll tell you what I see. What does it look like? How does he look? Does he look broken down? Does he look mentally unstable? To the extent I can tell, I will come back and I will tell you all of that. Rainic Storm is a new member. Thank you. Oh, thank you. Honest, in-depth coverage. That is high compliment. Thank you so much, Rebecca. I really appreciate that. And Mama Pinks, bets are in. Okay. All right. Bets are in for the courtroom page count. And it is 51 pages today. And they were some dense pages, some of them. Some of them not so much, but let's see. Let me just pull one up. So like, here's one. I always highlight it for you because if I were to read the entire thing, we would be here quite some time. So I highlight, and I'm trying to give you sort of the nuts and bolts fast enough so you hopefully have time to watch. It's an important case, and you can't have any access to it. So I don't want to cut out so much that you don't get the full flavor. This is the report that I can make. The media, mainstream media, a newspaper can give a short article that you can read, but it can't do the in-depth coverage of here's what really happened, which is what I'm trying to do. All right. LA Mac has been a member for 1 month. That's great. That is great. I'm glad you're appreciating it. And Vesper, thank you for saying thank you. Pretty Pearls, I appreciate that. Thank y'all so much. Atticus, what the heck kind of screaming at the top of Atticus's lungs? What the heck kind of training do law enforcement officers receive in this area of Indiana? And that's the defense says this was a really poor investigation. The loss of the first 5 weeks, I think it was, maybe even 6 of the interviews. How does that happen? I mean, that's crazy. Those are so important, critically important. And I don't know how that even occurred. And then another period of time when they lost video and all they have is video, but no audio, which is really useless for an interview. DB Bentley, thank you. Very generous. I appreciate that. And Carrie and Luke's channel, thank you for the super sticker. I appreciate that. A friend of St. Frank, Salem witch trials approach common food fund. I'm not sure what you're saying to me, friend of St. Frank, about the population and all. Kat Joselle, I think it's Joselle. Have you checked if the court would supply hearing support? I did. I did check on that. They just looked at me like I was absolutely, positively insane. They were like, I'm like, do you have like headphones for people with trouble? They're like, no. You made that. Who would have that? But we're busy having people move the microphone away from them. Why would we provide help for people with hearing problems? So nope, they do not have that. But I did. It was a good idea. And I checked that. Michael Lalonde, thank you so much. I appreciate it. And Catherine is a new member. And Lori Hurst is a new member as well. Well, I will take just a question or two. We have gone really long. I have a huge day tomorrow. I'm going to be on with Lawyer You Know. I think it won't appear until Monday, but we're going to be doing an interview tomorrow. And of course, I've got trials until probably 1 o'clock. And then we've got that interview. And then we've got our live stream. And then we have our members only. So it's one heck of a day tomorrow. So I'm not going to stay too late. I'll take a question or two. So Whit James is asking, would I take the case to trial with all of the missing evidence and little evidence that points to Richard Allen? That's more from the prosecutor's side to answer that. And the prosecutor, I don't think it's a frivolous case. I think they have enough that they could take the case to trial, but it's light. It's real lightweight evidence. And I would feel better as a prosecutor letting in a lot of the other evidence and letting the jury make the decision about whether they bought it, whether they really believed Richard Allen did it beyond a reasonable doubt. That's what I would feel more comfortable with. But that evidence won't be in. I don't think it's a frivolous case at all. I mean, there is some evidence. It's not none. All right. So, Kathy S., will the defense ask about the blood at the alleged crime scene? If there wasn't that much, then where did it go? I would imagine they're going to have an expert on that. They haven't presented their experts yet. We'll probably get to that maybe next week. I think tomorrow they have planned to show that video and maybe a few other witnesses, but I bet next week we get to their experts. We don't know who all they have. They also will be making a proffer of some more evidence around that third-party culprit. They do have to show the nexus, as the judge pointed out, where there's a connection between the crime and the person or group that would be called out by them. So she is allowing them to submit the proof, but she doesn't believe they have the proof. She's already ruled they can't bring it in. Could she change her mind? Yeah, in theory, but she's not going to. I don't think that's going to happen. Will you be able to hear the proffer? Carmina asked. I think so. I believe that will be done in open court. It was this summer, so I don't see why she would close it this time. I think, yeah, that will be available. I'm very, very interested to see it. We won't see again what they presented this summer. She's told them, whatever you did this summer, you can just port it right into this time, and I'll count it. You don't have to present all those witnesses again, because the jury's going to be just sitting there away from home, away from family while this gets presented. So she wants to keep it as short as possible. I think that was a good solution there. Can try an empty tin can. Nancy, I love that. I also thought about one of those big trumpets. You point it toward the witness one more time. But yeah, I haven't done that yet, but I like that idea. Younger Dreyfus. Maybe I could get the witness to talk into the can. Of course, they won't let them talk into a microphone. So I'm sure they would not be allowed to talk into the can on the other end of my string. Younger Dreyfus, do you think the jury can see the bias that the judge has shown? There is no way to answer that. The general rule of thumb, and this is just the way it is, you can say presumption of innocence all you want. There is no presumption of innocence when it comes into the courtroom. The jury comes in kind of believing that the prosecutor wouldn't have accused this person unless they were guilty. And that's just a bias we have as a society. It's not something that's bad, and they're trying really hard. It's not that they want to feel that way. It's just kind of a natural reaction. Well, this person, there's probably some good evidence. Otherwise, they wouldn't be being prosecuted. Now, let me make this decision about whether or not they're guilty beyond a reasonable doubt. So for that reason, it could be going either way. The jury could be sitting there thinking, wow, the defense is trying to get away with so much stuff. Thank goodness the prosecutor and the judge are here to stop that. Or they could be thinking, wow, the defense is trying to just get some basic facts to us, and the prosecutor and the judge, what on earth? They will not let them tell us anything. We don't really know. We don't really know which way the jury is leaning. And there's a possibility that some are leaning one way and some are leaning another. We get little clues and hints, like the fact that the men up on the upper row seem to really be struck by the fact that this guy kept getting shown his deposition and he'd said something different, and it was just 3 or 4 weeks old. So that might indicate that maybe they thought that that particular witness anyway wasn't straight up answering. But other than tiny little clues, which you could easily be misreading, we don't have any way to know the answer to that. Well, all right. I will see you all tomorrow night. I'll probably be able to go right at 7, since although I do have an interview, but hopefully I can get ready by 7, and then followed by the members only. So you can join as a member by hitting the join button on anything except your iPhone. And if you can go to your computer and join by hitting the join button beside Lawyer Lee, and that's how you join. Some of you might be lucky enough to get a gift membership, and that would be great. I'll look forward to seeing all of you tomorrow. We are celebrating this, I think will be our next to final day. We hit 175,000 subscribers about a week ago, and so we have a special outro by our moderator, Marlon, our other moderator, Mama Pinks. Huge thanks to both of them. Let me make sure I don't have anybody. Oh, Amanda Thee. Do you think the Supreme Court of Indiana is watching? Hopefully. Hi, Supreme Court of Indiana. I hope they are. I hope that they're watching, because I do think it's really important that the state rethink the rules and plans around making trials open and making trials accessible. I think it really matters. I think it's important, and I hope they will do that. See you tomorrow night. Let's go. Woo! Trying that again.